In this lesson, you'll be introduced to bankruptcy law, client rights in bankruptcy. By the end of this lesson, you should be able to describe the different forms of bankruptcy, explain what debts are and are not discharged under bankruptcy proceedings, and discuss alternatives to claiming bankruptcy. Bankruptcy is a constitutional right under the U.S. Constitution. It is a legal declaration that a person or a business is unable to pay its creditors. As a federal law, it's basically consistent from state to state, although individual states may have certain exemptions. Personal bankruptcy has become very common in the 21st century, and practitioners are finding it necessary to discuss the possibilities of bankruptcy, its ramifications, and possible alternatives with a significant number of clients. Note, however, that any discussion of bankruptcy with a client should only be in terms of the general law, since only a licensed attorney can give legal recommendations. Bankruptcy procedures include Chapter 7, Consumer Liquidation, Chapter 11, Corporate Reorganization, Chapter 13, Consumer Repayment Plan, Chapter 9, Municipalities Reorganization, Chapter 12, Farmer and Fishermen Reorganizations, and Chapter 13, Cross-Border Reorganization. In this presentation, we will explore Chapter 7, 11, and 13. Chapter 7 bankruptcy is a liquidation event. The person, partnership, or corporation legally declares the inability to pay creditors, and in exchange for liquidating most assets and distributing them among the creditors, the person or the business entity is given a fresh start. Property that is typically exempt from liquidation include a residence, car, qualified retirement benefits, work-related tools, child support, alimony, and Social Security. Note, however, that exemptions are not consistent from state to state. Remaining assets will be liquidated by the bankruptcy trustee and the proceeds distributed among creditors. Chapter 7 bankruptcy is subject to a means test, which determines if the individual has a level of income that allows for repayment of the debts. Furthermore, if the individual has income exceeding the median income for the state, creditors can object to the case proceedings in bankruptcy. In this case, the judge decides if the proceedings should continue. Chapter 7 bankruptcies are available once every 8 years. Chapter 11 bankruptcy is primarily used by businesses, sole proprietorships, partnerships, and corporations. Rather than a liquidation of the business, this form of bankruptcy involves company reorganization that is court approved. The business shows a plan for reorganization and how it can improve operations and pay back debt over time. The debtor works out a plan to solve the financial problems under the supervision of a federal court. It can best be described as a reorganization plan to help the debtor get back on its feet without pressure from either creditors nor fears about liquidation. Note that an individual may use Chapter 11 bankruptcy, although Chapter 13 repayment plan is more common. Chapter 13 bankruptcy is a repayment plan for individuals, even if that individual owns an incorporated business. The debtor keeps all property, but agrees to make regular payments to the trustee out of future income. The repayment period is typically 3 to 5 years. However, the amount of the payment and the duration of the repayment period is a function of net worth and debt owed. Individual retirement accounts, IRAs, are generally not subject to liquidation under bankruptcy law, although there might be a state cap over which the individual retirement assets are subject to bankruptcy proceedings. Furthermore, qualified retirement plans are not subject to creditor claims if an anti-alienation clause is incorporated in the plan. And generally, 401k plans and qualified pension plans have this clause. Knowing this, a planner should verify the inclusion of that clause in the client's retirement package as part of due diligence. Many debts are discharged during bankruptcy proceedings, particularly unsecured loans like credit card debt. However, not all debt is immediately discharged. Secured debt is typically carried forward. Other debts that may not be discharged under bankruptcy include child support, alimony, debts caused by injuries due to driving intoxication, fines and penalties, and income tax. In addition to various state exemptions from the prior slide, federal law precludes the discharge of taxes, money owed from false pretense and malicious acts, student and government loans, alimony and child support, liabilities from drunk driving, and criminal fines and penalties, embezzlement, and certain credit card charges. In addition to various state law exemptions, federal law provides exemptions for qualified retirement plans and their rollovers, IRAs to $1 million on an index basis, and covered out educational accounts and 529 plans made at least 2 years before the bankruptcy filing. If creditors have a valid claim against the debtor that exceed the value of any security they hold by more than $10,000, and the debtor is not paying debts as they come due, an involuntary petition for bankruptcy may be filed. When the involuntary petition is filed against the debtor who owns a business, the debtor may be allowed to continue the business. However, if there is a valid concern that the debtor business owner may try to sell the business and assets at less than fair market value, the court may appoint an interim trustee. The interim trustee is there to protect and preserve the bankruptcy estate for the interests of the creditor. The reform law requires individuals, including sole proprietorships, who file for bankruptcies to receive a briefing that outlines the opportunities for creditor counseling and that assists the individuals in performing a budget analysis. The briefing must be provided within 180 days prior to the bankruptcy filing. After the filing, an individual must also complete a financial management instructional course before discharge. Bankruptcy is a viable option for a fresh start. However, there are serious ramifications. The bankruptcy filing stays on the credit report for 10 years, and a person will have great difficulty in getting a loan in the future. Furthermore, studies have shown that bankruptcies don't always change bad financial habits. That is why alternatives to bankruptcy should be explored prior to going through court actions. 6 alternatives are listed on this slide. 1, a debt consolidation loan. For example, eliminating credit cards. Negotiation with creditors. Proposing your own repayment plan. Commitment to a realistic budget. Getting a temporary second job. Or using a line of credit. In this lesson, you learned about the different types of bankruptcy laws, debts that are and are not discharged under bankruptcy proceedings, and alternatives to claiming bankruptcy.